Two people get into a serious dispute today, and there's an entire system ready to handle it. Police, courts, judges, lawyers, jail cells, an entire profession, an entire building, an entire paperwork trail, built just to answer one question: who was right? All strangers deciding your fate using rules written by people you'll never meet. Your dispute becomes a case number, decided months or years later, by people with no personal stake in your life at all. Now remove every part of that system. No police, no judge, no written law at all, no case number, no months-long wait for a hearing date, no lawyer arguing your side for a fee. Just the same 20 or 30 people you'll live next to for the rest of your life. No walking away and never seeing them again. Whoever you fought with today, you'd be sharing a fire with tomorrow. So when two of them wanted the same thing, or accused each other of wrongdoing, who actually decided who was right? The honest answer isn't no one. Let's start with the simple fact that no law didn't mean no rules. In 1954, legal scholar E. Adamson Hoebel published a landmark study called The Law of Primitive Man. He surveyed dispute resolution practices across dozens of small-scale societies. With no police, no written law, no formal courts, his conclusion was clear. Every single one of them had a working system for resolving conflict anyway. No two societies did it quite the same way, but nearly all of them shared one trait. The process had to be visible, and it had to feel fair to the people watching. Not chaos, not simply whoever was physically stronger winning. Structured, recognized methods that the whole group treated as legitimate. Almost always resolved in public, in front of the very people who would have to keep living together afterward. Justice wasn't handed down from above, it was worked out from within. No one sat above the process, looking down at it. Everyone sat around it, looking at each other. The specifics varied wildly from place to place, but the need for a legitimate process never disappeared, even without a single police officer anywhere on the continent. S32 Image Prompt. Scene: Parchment info card. Text: The Cheyenne Way, 1941, Carl Llewellyn and E. Adamson Hoebel, with a simple line art icon of a teepee camp circle, light parchment background. Hoebel later co-authored an even more detailed study with legal scholar Carl Llewellyn called The Cheyenne Way. They gathered dozens of real trouble cases, actual disputes remembered and retold by Cheyenne elders in detail. Serious disputes, including killings, were handled by recognized camp figures, not a government, but individuals the whole community already trusted to mediate. Among the Cheyenne, these were often members of specific warrior societies, respected enough that their judgment was rarely challenged openly. Even killings were rarely met with execution. More often, the resolution involved temporary exile and compensation paid directly to the wronged family: horses, goods, a public acknowledgement of harm done. The exchange itself was performed publicly too. Everyone saw the debt acknowledged and paid. The logic wasn't about erasing the offender. Every hunter, every toolmaker, every extra set of hands mattered directly to whether the whole group ate that winner. It was about repairing a very specific, very real tear in a small community that couldn't afford to lose anyone permanently. In a band this small, permanently losing even one able adult was a real cost the whole group would feel. One of the most striking versions of this shows up in the Arctic. Among various Inuit groups, serious personal disputes were sometimes settled through something called a song duel. Two men with a grievance against each other would compose insulting songs and perform them publicly in front of the entire community. Not veiled criticism. Direct, humiliating, often crude insults turned into rehearsed performance. Sometimes the whole camp gathered specifically to watch. treating it as a real event, not a side conversation. The audience watched, laughed, and reacted. A weak insult or a clumsy performance could visibly turn the crowd against its own singer. Once the performance ended, the grievance was considered settled, publicly, completely, without a lingering feud. No years-long appeals process. The verdict landed the same night it was performed. Whoever earned the most laughter, the most social approval, effectively won the dispute. No physical violence required. No authority handed down a verdict. The entire community, through its own reaction, decided who was in the right. So resolving conflict just meant talking or singing things out casually? Not quite. These weren't loose, spontaneous arguments. They were highly structured, rehearsed, and performed publicly with real, lasting social consequences for losing. Losing a song duel could brand a person's reputation for years. Composing a genuinely devastating insult song took real skill, practiced well before the actual conflict ever came to a head. Even everyday storytelling carried more weight than it might seem. In 2014, anthropologist Polly Wiessner at the University of Utah published research on the hoansi of the Kalahari. She compared what people talked about during the day, while working, versus what they talked about at night, around the fire. Daytime conversation was mostly practical: complaints, economic matters, coordination. Nighttime, firelit conversation shifted dramatically towards storytelling. Wiessner found nighttime conversations ran far longer and covered far more emotionally loaded ground than anything said during work hours, often involving pointed, humorous tales about specific people's bad behavior. These stories spread values, reinforced group norms. Children absorbed exactly which behaviors earned respect and which ones earned a story told about you for years. S72 image prompt. Scene: parchment info card. Simple icon of a child growing up beside a stack of remembered campfire stories, gradually absorbing them into behavior. Light parchment background. Every child grew up already knowing the unwritten law, simply from a lifetime of hearing which stories got told and which behaviors got laughed at. No rule book needed. The stories themselves were the rule book, and quietly punished bad behavior through embarrassment, without a single person ever being formally accused of anything. The fire itself, Wiessner argued, functioned as a kind of nightly court, run entirely through story and reputation. So does having actual police and courts today make all of this obsolete? Not exactly. In 1989, criminologist John Braithwaite at the Australian National University published research comparing two different approaches: purely punitive justice against what he called reintegrative shaming. Purely punitive systems, isolating and stigmatizing offenders, often produced worse long-term outcomes. A person permanently branded as an outsider had very little reason left to follow the group's rules at all. Once someone stops believing they belong anywhere, there's nothing left tying their behavior to anyone else's approval. Higher reoffending, more permanent social exile. Approaches that shamed the specific act, while actively working to bring the person back into the community afterward, performed measurably better. The distinction mattered enormously, condemning what someone did without permanently condemning who they were. In other words, some of the most effective modern criminal justice research quietly rediscovered a preference the hoansi, the Inuit, and dozens of other small-scale societies never abandoned in the first place. Ancient conflict resolution rarely happened in private. It happened in front of everyone, in song, in story, in open camp discussion. The goal usually wasn't punishment for its own sake. It was making sure the group could keep living together the next morning. Every method, the song, the story, the compensation, the mediated exile, pointed toward the same finish line. Staying together, not tearing further apart. None of this means modern courts are worse across the board. Consistency and formal rights matter too, in ways small bands never had to worry about. But something about scale changed what conflict resolution actually felt like for everyone involved. We built prisons, case files, and appointed judges to carry that weight instead. What we lost in the process was the felt sense that everyone in the room had a stake in getting it right. S99 image prompt. Scene. Parchment info card. Simple icon comparing a modern case file folder against an ancient campfire circle connected by a dotted line. Light parchment background. A verdict on paper and a seat still saved by the fire were never quite the same thing. One of them closes a case. And that stake was never really about the verdict. It was about who was still willing to sit around the fire with you afterward.